Hi, guys, it's Carolyn, and welcome back to the podcast. And today we're going to talk about all the dangerous things in shitty commercial subcontracts with a fellow attorney who knows that one of those contracts you'd rather burn it than try to fix it. In my humble opinion. Today we have Eric Wagonheim. Eric, I'm sorry,
That's okay.
Eliot Wagonheim. Eliot is a teacher and a national public speaker, as well as a seasoned 37 years and counting, and fairly cynical construction lawyer. In 2018, he founded First Rule Contract Training because he realized that teaching construction professionals how to avoid problems was vastly preferable to profiting off those problems as a lawyer. In 2022, Eric was engaged by Pro LLP, a national accounting and consulting firm, to teach construction law to its proprietary AI, which has now been relaunched as First Rule Construction. Well, that's exciting. Welcome to the show, Eliot. How are you?
I'm doing well. I did notice that at the outset you said that I'm going to talk about all of the problems with commercial subcontracts, but I respectfully submit that I don't think we have that kind of time.
True, very true. We'll talk about the big ones that
We
are
can talk
always
about the big ones.
consistent in the same thing. Before we dive in, tell us a little bit about yourself and how you got to where you are now.
So, as you mentioned, I'm a construction lawyer. I've been a construction lawyer for 38 years now. And I realized that in working with construction companies, particularly for arbitrations and litigations, that my professional role was kind of akin to being like flowers at a funeral, always getting there just a little bit too late to do anybody any real good. And I vastly preferred teaching construction professionals, construction firms, how to avoid problems before they became problems. And I like the transactional work. I like drafting contracts, but I really like teaching. And so I was doing a lot of work teaching construction companies one at a time, all-day workshops, half-day workshops. And I was asked to put some of this online for asymmetric, which made sense because, or asynchronous learning, which made sense because, the pandemic came shortly thereafter and everybody was doing, asynchronous. So I did that. And then I was really excited to partner with, at that time it was Crow, but it was really a team led by Rhonda Huseman, who was a Crow partner, and she had developed the idea for an AI construction contract review software, and we started working together, where my role was to teach construction law to the AI. And with her team, Rhonda had started developing what became Contract Manager, and then spun it out from Crow, so we were able to join forces in First Rule Contract Manager Corporation almost exactly a year ago. So we have the AI side and the teaching side. So that's kind of the bring you up to speed part.
Gotcha. So let's go ahead and dive into what do you think about construction contracts? And now we're talking about, I know this is generally on commercial construction, correct?
Correct, yes.
Because residential contractors get to write their own contracts.
Whole different animal.
No, I agree from a legal perspective. So are you dealing mostly with generals to owners, subs to generals? What is
All of it, everybody in the built world, really. So owners, generals, subcontractors, second tier subs, some suppliers, everybody in the food chain.
Gotcha. All right, so let's kind of start by diving into what are some of the most dangerous contract provisions and how do we fix them?
Okay. So I think one of the most dangerous contract provisions for a subcontractor is the flow down provision. And I know everybody's going to point to indemnification and liquidated damages and all of the usual suspects. And I get that. And I'm not saying that that's not a legitimate answer. But I'm saying first I'm pointing to flow down, because what flow down, as you well know, says is that, yeah, I'm signing a subcontract agreement as a subcontractor, but there's this whole other set of contract documents, the prime contract between the owner and the general and any exhibits and schedules and all that stuff, that are tied to the prime contract. Well, I, as the subcontractor, I didn't sign that. I may not even read it, but it's legally binding on me, and that's brought home through the flow down provision. And I will tell you that I speak on this all across the country, and one particular meeting just sticks with me. I was speaking to subcontractors, and I said to them, do y'all read the prime contract before you sign your subcontract agreement, assuming that it's incorporated by reference into your subcontract? And, a lot of people are like, no. And so I said, look, I know I'm asking a lot, but I'm asking you if there's somebody brave enough to tell me why. If you know the prime contract is one of your contract documents, why don't you get a copy of it? So this guy in the front row, and this is what sticks with me, this guy in the front row raises his hand and he says, because if I got a copy of the prime contract, I'd have to read it. I was like, yeah, that's true. You'd have to read it. And I just never forgot that. But anyway, so the flow down provision is incredibly dangerous because subcontractors can be held liable for obligations and terms they've never even seen before.
Yeah, what I always tell my clients is it's lazy lawyering. If I forgot something, it's in here.
That's exactly right.
Exactly what it is. It's like, okay, if I forgot something, it's in here. But in practice, and so I've been pretty successful at, and so what we're talking about the flow down provision is what I like to call is when in the first couple paragraphs, it says the prime contract is hereby incorporated, thereby making that document part of the document you're agreeing to and you've never seen.
Exactly.
I've been pretty successful at getting copies of it, obviously redacted in price. What provisions have you seen that contradict the subcontract being enforced in reality?
So there are certain things, for example, I was reviewing a contract the other day and it was warranty. The subcontract says the subcontractor shall provide a warranty that extends 1 year from the date of completion of its work. But the prime contract says that the contractor shall provide a warranty that extends for 1 year from completion of the project. So you've got a conflict there.
Mm-hmm.
And as you well know, the conflict provision generally points out, well, what wins? And in a subcontract agreement, 9 times out of 10, at least in my experience, the subcontract agreement will say that in the event of a conflict, either the prime contract controls or the stricter or highest standard controls.
Exactly.
In which case, in that example, both of them would say, well, depending upon what the trade is, the subcontractor could have extended its warranty far beyond what it had intended. And so that's one of the prime areas of conflict. I see notice provisions a lot, where the prime gives a different notice provision than the subcontract does. And notice, as you know, it's often overlooked and extremely important because if you don't comply, you could be deemed to have waived your right to something, relief under force majeure, or the right to payment for a change order.
Mm-hmm.
So I see those. A lot of times it's the absence. So in a subcontract, the subcontract agreement might be completely silent as to say liquidated damages. And I'm a subcontractor and I'm reading this and I'm really worried about liquidated damages. I'm like, whoa, that's great. There are no liquidated damages for which I could be liable. But the prime has them, and so that's one of your contract documents. So it's things like that are just kind of the silent, under the radar company killers that I tend to focus on.
So you get it and you see those provisions before you sign it, then what do you do? So do you negotiate it? What do you try to do?
So yeah, I do negotiate it. And you have to be aware of the limits of a negotiation. So for example, if there are liquidated damages in the prime, the general's held liable for liquidated damages if they pass a certain date. And that flows through their subcontract. And I'm, as a subcontractor, if I call the other side and I say, yeah, I really don't like this liquidated damages thing, so let's cross that out. You can have that conversation, but I seriously doubt that that's going to go anywhere. So if you want to have that conversation, that's fine. But a more productive conversation might be, okay, I get that liquidated damages passes through. And you, as the general contractor, have to have a way to hold me accountable to the dates, particularly if you're being held accountable for the dates. However, I want to make sure that if I'm going to be held accountable for delay, the only delay for which I'm going to be held accountable are those that I caused.
Yeah.
My negligent acts or omissions or my breach of contract, or those for whom I'm responsible, my subcontractors, my suppliers. And what that does, if you get agreement, and generally on the phone you can get that agreement, but the language of the contract is broader than that. It might just say that I'm held liable for $1,000 a day for every day beyond September 1st for which we don't achieve substantial completion. But by inserting that I'm held responsible for $1,000 a day for any delay for which I'm responsible, now I've introduced an additional hurdle for the prime, or by extension the owner, to clear before they assess liquidated damages. It's not just the turning of the calendar pages.
Yeah.
So yeah, there are many ways to negotiate subcontracts, but you have to know how to approach it to get agreement to the general themes before you just shoot a red line over the net and hope that the other side reads it.
No, I agree. I agree. And a lot of this too, like I tell my clients, like in an ideal world, I wouldn't sign any of this, but I'm telling you what the risks are, and then you can assess from there.
That's right. That's right. Look, there, in my experience, there is no construction project, no construction contract that doesn't carry risk. So you're not going to go to your construction clients and say, all right, I'm going to show you how to eliminate risk.
Yeah, really.
Because, well, I mean, in all fairness, I could show them how to eliminate risk, but I would also eliminate their ever doing any work for anybody again.
I agree.
But in this industry, it's not a matter of eliminating risk. You have to accept what risk you have to accept, but really the goal in contract negotiation is to look at it as a risk transfer vehicle and look at the provisions and see, okay, how can I reduce the risk, or how can I transfer the risk? Either back up the food chain saying I'm accepting some but not all, or down if I have subcontractors or suppliers to say if I'm hit, you're hit. So that's kind of the way to look at it. But eliminating risk is just not going to happen.
Like I tell my clients, unfortunately, the only successful projects I ever see are the ones I drive by. I don't ever get involved in the ones that don't have any issues.
That's a great line. I might steal that line.
Because it's like, we bring you this big bad rain cloud and be like, there's tons of projects that get done and don't ever have a lawyer, but I only see the ones that need lawyers.
That's exactly right. Yeah.
Okay, so that the flow down provision. What are some other provisions?
Well, I think indemnification certainly, because when you take a look at indemnification, there are several things to discuss and one thing you can't. The one thing that you can't discuss is, or productively anyway, is to call the other side and say, I'm not crazy about this indemnification thing, so I just want to take that out.
Yeah.
Yeah, that's not going to go anywhere. So you look at what you can discuss with indemnification. As you know, indemnification really roughly translated means I will become your insurance company if.
Mm-hmm.
Right? So you can discuss the limitations on that. Maybe the language that says any and all damages. You might want to say, well, subject to the exclusion of consequential damages, for example.
Yeah.
If you're able to negotiate a limit of liability, some trades are, some contractors are, great. Then it's up to the limit of X number of dollars, or the insurance coverage, or the defined term limit of liability.
Mm-hmm.
So you might be able to do that. You might want to clarify that your obligation to indemnify is only for third-party claims, meaning you can be held responsible for breach of contract in a normal breach of contract action, but it's not indemnification. You're only indemnifying for third-party claims. And one of the reasons I highlight that as being important, and not just like lawyer technical talk, is that if you do have a limitation of liability or a waiver of consequential damages in your contract, very often those provisions will say that they apply to everything except your indemnification obligations.
Yeah.
Well, if indemnification is limited to third party, okay, I can accept that. They get tagged for something we did, we get tagged for something we did. I understand that. But if the indemnification provision is broad enough to encompass my breach of contract, then that limitation of liability or that waiver of consequential damages that carves out indemnification from those protections means I'm not protected by those things at all.
Mhm.
So you want to cut that out of indemnification. And to the extent possible, you'd like to make sure that your indemnification obligation and any damages that arise from that are restricted to the damages that you caused through your negligent acts or omissions, or those for whom you're responsible, like your own subcontractors or employees.
Correct. And I think that's kind of the best way you can protect yourself. Obviously, indemnification has a provision like if you cause damage, you're going to be responsible. And I think that's completely normal. It's when they try to stretch it to cover the GC's wrongful act or the owner's negligent wrongful acts,
Right.
where it gets out of control.
It does.
And so I think those are some good points in trying to negotiate. You're not going to get rid of indemnity. It's not going to happen.
No, you're not. But sometimes those provisions are so broad that they cover things over which you have no control whatsoever.
No, I agree. And have some states kind of by law made that unenforceable?
Yes. A number of states have made it unenforceable. Florida is one. There are a few. I think North Carolina is another. And you do see the broad indemnification statutes or provisions falling out of favor. But, I wouldn't look at it if I'm a Florida contractor and you've got this broad indemnification. Yes, you can take some comfort in the fact that the state law would render that unenforceable, but there's no guarantee that the state law won't change.
True.
Or that the language of the state law encompasses everything you need to protect you. So it's still, in my opinion, it's not the best practice just to rely on the statute rather than build in the actual protection into the contract.
I agree, because then you're talking about litigation to talk about enforceability of the contract.
Exactly.
Instead of just being upfront about it.
Yeah.
Okay, so it flowed down indemnification. What's another one?
Well, I'll go another unconventional one, and that's the notice provision. And here's why.
Notice to cure, notice to...
It's how notice is defined.
Gotcha.
So, for example, you can picture, I would ask contractors to picture themselves in a claim. They're in arbitration, and they're claiming $250,000 in change order work. And they've raised their right hand to tell the truth, the whole truth, and nothing but the truth. And the lawyer on the other side says to him, "Did you provide my client with notice that the work items for which you're now seeking payment were outside the base scope of contract?" And the answer is confident. Absolutely. I spoke to him 3 times. I sent 4 emails. I even met his superintendent at the site, and we talked about it. And that's when the lawyer kind of backs up and says, I'm sorry. I asked my question badly. The contract defines notice as a detailed description sent by certified mail, return receipt requested to the Vice President of Construction Operations in Boston, Massachusetts. Let me ask my question again.
Yeah.
Did you provide my client with notice as it's defined in the contract that the work for which you're now seeking payment was extra? And that space in between when the lawyer finishes his or her question and you begin your answer is the space where your $250,000 claim just died.
Yeah.
Because the answer is no. So notice is one. Another one that's unconventional, but I think sows the seeds for so many disputes, is the definition of contract documents.
Yes.
Because I can't tell you how many claims I've seen where a contractor says, "You can't hold me responsible for that. It was clearly excluded in my bid."
Yeah.
Right? And then you have the same reaction I do, and you're like,
"Did you read the scope? Did you read the project manual? Because that's what matters."
That's exactly right. Read the scope. Read the definition of contract documents. Do you see your bid anywhere? Because if not, it's as if it never existed. The entirety's provision says this supersedes all of our previous discussions.
And then how I say it is like, you send over a bid, that's an offer. The subcontract is a counter offer. Look at it as if you're bidding a new job, because there's going to be something different.
Yeah, absolutely there is. So those are things that I see all the time as being exceptionally dangerous, and the risk is underappreciated.
No, I agree absolutely, and I think that's something that's completely within their control. Is just not. Don't think the bid is part of your work. If you're lucky enough to get the bid incorporated, you're still going to have to see what conflicts with the scope documents.
That's exactly right, and what has precedence. Another is it's not the project schedule that's dangerous. I mean, you can evaluate the project schedule, see what makes sense. What's dangerous is the provision that says contractor or subcontractor will perform its work in strict accordance with the project schedule. And you're signing off, except the project schedule isn't attached.
No, or it's
Or, the,
out.
or it's out of date, right? The project, you're sitting here at the end of September, and the project schedule that's attached assumes you began work in May.
Yes.
And you've got liquidated damages, dates of substantial completion, you've got other delays attached to this, and you've just signed. The moment you sign, you're going to be in default.
Yeah. And making sure, that's what I tell my clients, make sure it's correct, because everything is based on what you sign. It doesn't matter what you said. It doesn't matter what an email says. You can't change it later. Make sure it's right the first time.
Right, exactly. And a lot of people, I won't say fall for this, because I don't think it's really intended to be a gotcha thing. But the trap that they do fall into is where the other side says, I know the project schedule's out of date. Just sign it. We need to get our contractors locked down. So why don't you sign that, and the paperwork will catch up?
Yeah.
And that's a problem, because you've signed something that you can't honor.
No. From the get-go. And because they want to push you to get to work, and it's like, no, this is one of the easy things that you can easily push back on. Hey guys, my liquidated damages is tied to this completion. I can't sign this. Right. And I
Right.
really do think like you're in the same boat as me, the more we educate and the more people can push back and get somewhere, the more these things will change.
No, and in a similar vein, you have change orders, because we're sitting there, and both the sub and the general, they know that what has to be done is outside the base scope of work. It's change order. So the sub submits a request for change order, and the general's reviewing it, and the owner's going to review it, and all this stuff. But the calendar pages keep turning. So the GC, or the owner to the GC, says, hey, the paperwork will catch up. Why don't you get started? So you're between a rock and a hard place, because you want to maintain that relationship. You want to be a team player. You certainly don't want delay damages. But the contract also says that if you proceed with change order work without a fully executed change order, you may be deemed to be waiving your right to payment. So you've got that rock and a hard place issue. So that's one of the dangerous parts of it, of where being a team player really conflicts with what the contract actually says will happen.
What about change order directives?
Change order directives, you have, I don't know what your experience is with them. The CCDs, what I often see is that the other side is judge and jury on not only what has to be done, but how much is going to be paid, how much time is going to be allowed. And what's your recourse? Your recourse is maybe you can file a claim under the dispute resolution provision, but you're still stuck with that. I don't like CCDs for either party, because I think it's destructive to the relationship. And I think it cuts against the collaborative nature that characterize the best of projects.
No, I agree. And some workarounds we found for that is let's put out what the formula is, right? Time and material plus a certain percentage.
Right.
That way we know what if we can't, if we can't agree. And the other thing I tell my clients to do is, obviously you can't stop working, right? Regardless. Is that you got to keep going. So document, send the email, send the notice, and if we have to, then we'll file a lien for it. I mean, that's the best way I can come up with to go around that situation. Some of the ways that we've been successful, but it is a rock and a hard place.
It is, and you're right. You have to build the record as best you can. A CCD might be an arrow in the quiver of the GC, but you have to build the record as best you can. And sometimes that does mean, well, we're going to put into the contract that if there are change orders on a T&M basis, here are the hourly costs, here are the unit costs, or whatever it happens to be. So maybe in negotiating a contract before it ever arises, you eliminate at least some of the points of contention.
Right. All right, what else you got? You haven't gotten to some of my favorites.
What are your favorites? Give me a favorite.
The biggest one, in my opinion, is the freaking pay when paid. That is
Yeah,
just,
so the pay when paid kind of reminds me a bit of indemnification in certain respects. The first one is that there are a number of states that have rendered them unenforceable.
well, pay
Right?
if paid is unenforceable, but
Pay
not a
if
pay
paid,
when.
yes. Not pay when paid, but pay
And
if
that
paid.
comes down to a legal argument. I mean, how is that going to help you during the project?
It's not. It's not. And that's where you take false comfort in it. The other side says, well, we have a pay if paid in our contract. You say that the state law says it's unenforceable. So I'll tell you what, we will hold on to the money until somebody who wears a black robe tells us we can't.
Exactly.
And that takes a while. But pay if paid is the bane of most contractors' existence, most subcontractors' existence. And so you can, again, like indemnification, it would be doubtful if you can say, hey, I don't like this pay if paid provision. I'm going to just cross it out. I don't see how that's going to succeed. You can try, but I don't see. So you can start to nibble around the edges a little bit. So it's not just if you didn't get paid, but if our delay in providing this change order and our delay in providing documentation is the reason you didn't get paid. In other words, I've had general contractors who just kind of lose the requisition, lose the application for payment, or don't get it in. Well, that's your problem. That shouldn't be my problem.
Yeah.
So let's limit the pay if paid to the extent possible to something arising from my acts or omissions.
My delay, as much
Yeah,
as possible. I know, like in Texas, there is actually a letter that you can send after you haven't been paid 45 days that says, if I'm not the reason you're not getting paid, you need to pay me. It's questionable on its enforceability because they'll come back and
right.
be like, well, they're withholding liquidated damages and that you might be responsible. So, it's better than nothing because eventually if you send somebody notices, you do have the right to stop working under the contract. But again, you have to get a lawyer involved. It's not something you do on your own.
Right.
Uh, what I tell my clients is be ready to cash flow the whole project, right? I mean, that's the risk is that something
Yeah.
goes wrong and you're going to have to work and not be able to stop because technically you're not entitled to payment. So you have to keep going.
Right. So at that point, as soon as you get the lawyers involved, you're really coming down to a question of who's going to lose the least amount of money, not who's going to make a profit
No,
on this,
exactly.
because that ship has sailed. You're really looking at, well, okay, hopefully we can lose less than they do, or than I thought I was going to lose. But
No, I did a whole series about how litigation sucks because I've never had a client be made 100% whole going to litigation.
no, it's and I went early in my career. One of my mentors, who was a judge in Maryland, told me that he believed that as a judge, he did his job well if both sides leave pissed off at him.
Sounds like a mediation, but yeah, I mean,
Yeah, it sounds like right. Any of these things, and because particularly in construction, I'd be hard pressed to think of something where somebody's 100% in the right.
yeah.
Unless it's just, well, I don't have the money to pay you, but ... But otherwise, and even then, they still find, well, but I think your calculation is wrong, or I think that, we have a little bit of a back charge here, or you didn't clean up the site, and so we're going to penalize you for this. So, yeah, by the time when you start to invoke that dispute resolution provision, it's like showing up in the construction trailer and seeing a guy in a coat and tie. Nothing good is going to come of that.
Exactly. Exactly. Another big one that I always hear about is termination for convenience clauses. That's a hot topic and kind of curious in your opinion position.
I think that's a very difficult obstacle to overcome because the termination for cause very often it either has, or you can negotiate the notice and the reasonable opportunity to cure and all that stuff. But termination for convenience is just it. They say, look, sorry, we can't move forward with this, and we're stopping work. And then once again, it's going to be incumbent upon the terminated contractor to obtain whatever recovery it can. But it's very rare in my experience to be able to negotiate the termination for convenience provision.
Usually most cases I can get it made mutual.
You can get it, yeah, if you can get it made mutual, thereby giving the contractor the right to suspend or terminate, most often for non-payment, but for
Anyway, yeah.
could be lack of responsiveness to the RFCOs or RFIs or what have you, then you've gained a lot of leverage for your client.
Right. Yeah, but I don't think they're going anywhere. So in your opinion, how did these things get this way? Most contracts, and don't be wrong, I guess bank contracts and contracts you have to sign with your credit card company are that way because nobody reads them. How did construction contracts get this way?
How do they get what?
How did they get this way where they're so one-sided?
As far as the origin is concerned, the thing that's unique about the construction industry, well, I say unique, you would have the same carve-outs that I would. Most of the time when you have a contract, let's say I'm a graphic designer, you're hiring me to work on your logo, or to hiring a professional to build your website or do something like that, we could go back and forth and we can come to a contract that is largely right down the middle. And also, we could probably make our arrangements to proceed with the assignment and cut down that contract from 10 pages to 2 pages or to 3 pages and make it plain English. Construction doesn't offer, certainly commercial construction, it doesn't have the plain English alternative. It doesn't have the, for the most part, the shortcut contract that just gets to the meat of things. You've got your 800-pound gorillas, AIA and consensus docs. And then you've got the people who have their bespoke contracts who just want to imitate AIA or consensus docs. And there are these long things. I mean, the table of contents for the A201, the general conditions, is like 12 pages. So you have a problem when the table of contents is 12 pages. So it's gotten to the point where if you try to draft a streamlined commercial construction contract, people are immediately suspicious. What are you keeping out? This isn't what we're used to seeing. You don't read what you're used to seeing? Yeah, but we're used to seeing it. We sign it. So I really don't know how it got that way. I do understand that for the most part, commercial construction is a complicated undertaking, right? It's not one guy with a hammer. It's complicated. It requires collaboration. It's got to be greater than the sum of all of its many parts. So I get there's complexity on the ground. I just wish that the complexity, on paper didn't mirror that.
Well, I tell my residential clients all the time, the job of the contract is to manage expectations. And I'm sorry, in the commercial industry, it cannot do that if one side can understand what's written.
That's right.
And it's like, you're going to have a better run project if you're just say it in freaking plain English and say what you got to say so we know what's going on.
There are a lot of times I don't think either side really knows. So I'll give you an example. I was brought in by a national construction company, and they had what I think was the really laudable idea of bringing in their main subcontractors, and they wanted me to teach their subcontractors what the contract actually said. Made complete sense. So I got to the part about termination for cause and for convenience. And I started talking about it. And these guys in back of the room from the National General, they said, that's not true.
I was like, yes, it is.
That's not how our contract works. And I said, yes, it is. And I walked them through it. And then what they said was, okay, but we'd never do that. I said, okay.
You did.
I respect that, from your philosophical, we don't want to do that and all that stuff. But you did do that. And that's what it says. And the fact that this may not be the way you would typically do business doesn't mean you can't enforce this. So that's what I mean. A lot of times both sides don't understand it.
Because the lawyer written it and they thought they're covered. But like I said, it could be so much better. I guess it could be so much better. I
Absolutely.
think we got here because before contracts, work was done on a handshake, and subcontractors are guys that want to go to work. And the GC had a contract written, and lawyers write things thinking that there's going to be a negotiation, and there never was. They just signed them because they trusted the people they work for and they wanted to go to work. And now we're here in this position where we have, and don't get me wrong, I think the general contractor is going to try to shift the risk somewhat, but at least do it in a way they can understand it and
Yeah.
know what it is and what's expected. I think the projects would be more successful. I don't understand why we're stuck here.
Yeah, and we really are stuck because there is something suspicious. And besides which, if I come into the general contract, if I'm anybody in within a large general contractor, and I try to streamline and clarify the contract, and God forbid something goes wrong, that's going to be on me.
Yeah.
And there's an inherent conflict, right? Because the essence of construction, the business of construction, is to do things with a high degree of precision. The joints have to meet, the corners have to meet, everything has to be done in accordance with the survey, and you have all of these things that you have to take care of. The craft of the lawyer is the opposite of that. We don't want to write with precision. We want to cast this broad net, and we want to make sure that we haven't messed anything up. So we have these phrases like notwithstanding anything set forth here under the contrary. So we said yes up here, but now we're saying no. And you also have something that says the highest and strictest standard. Okay, well, that saves us the trouble of actually telling you what the standard is. We kick that can down the road. Or in strict adherence to anything else in the contract documents. All right, well, that saves us the trouble of any conflicting thing. We're just referring to that whole universe of contract documents, and it's not precise, and it goes against how the construction industry is really built.
No, I agree. And it just, I'm a big proponent for making it better. Obviously, they're going to have to shift some of the risk, but I just, like I said, it manages expectations. And if nobody can read it or understand it, how can it do that?
Right, exactly. It not the first time in the legal profession it accomplishes the opposite of what should be intended.
True.
That's a whole different story on billable hours, but I won't get into that.
Oh, subscription and flat fees, honey. They're taking over the world.
That's as well they should.
I agree completely. I'm working on both of those models right now. So tell me a little bit about the platform.
So first role contract manager is we've got several levels, but the mastery level, the enterprise-wide solution, is something where at its basic you can upload a contract. It will do risk analysis. It will tell you the high, low, medium, and do not include risk and the weights of it. It will show you how you might want to think about revising it, how you might think of negotiating it. It collects institutional knowledge. So if you have in-house counsel or outside counsel that says we must have this language in our contracts, it'll make sure that that knowledge is not restricted just to that one person who's been doing it for 10 years. It's in the system so that as companies grow and scale, their contracts and their comments and their revisions remain consistent. But the part of contract manager, there are two parts that really stand out. First of all, it is industry specific. It's not industry agnostic. It applies specifically for construction. Along those lines, I've also spent 3 years training the AI in construction law. If you go out to a chat GPT and forgetting about the confidentiality problems, it's not trained in construction law. So the AI has to be trained and vetted. And then the second part of it is it intersperses the human part of it. Not just the analytics, but also the training, so that in the platform, there are over 200 videos that speak to you if you identify yourself as a subcontractor, if you identify yourself as a general contractor, that tell you, what does this term mean? How do you revise it? How do you negotiate it? And each of these are 2 to 6 minute videos. They're very short. It also includes deep dive courses in everything from in-project communication to negotiation and contract review and revision. But so it combines the AI and the training, and it integrates with Procore and Trimble and other ERP and other systems out there, anything with an open API. But we realize that a lot of companies, they know AI is there, obviously. And they've heard that we really should incorporate AI into one of our critical processes, which is contract review. But we don't know as much about it, and we don't want to sign a multi-year license for something, and we don't know how it works. And so we came out with what's known as Apprentice. Apprentice is an online month-to-month solution. It's very inexpensive. It's $795 a month. You can upload 5 contracts and get all of that same training. You can get all the analysis. You can ask the AI, for example. You can say, okay, I had a weather delay of 2 weeks and it cost me X number of dollars. Where in the contract is the relief? And it'll come up with the force majeure and whatever. But more importantly, it can say, okay, well, now that I've had that, can you write the notice compliant with the contract so that I can get the relief that the force majeure provision spells out? So the AI will go through the contract and figure out what you have to put in the release, in the notice, who you have to notify, and it will generate the notice for you. So it it really helps streamline the workflow. And I get the question all the time, well, doesn't this replace lawyers? And the answer is no. It doesn't replace lawyers, but it's a powerful tool at their disposal. I don't know of any construction company, no matter how close their relationship is with outside counsel or if they have in-house counsel, that can have a lawyer look at every single contract, let alone every single opportunity. There's just not the bandwidth there, and it's a budget item. It's too expensive. But you can arrange the life cycle so that you say, all right, for every contract over X dollars, the indemnification provision, the warranty, the liquidated damages, whatever, that's automatically routed to counsel. Or the Article 11, which is the insurance provision, that's automatically going to be routed to my insurance advisor to make sure that I'm compliant. Or, something goes to the surety. So it can help streamline what could otherwise be a chaotic and inconsistent contract lifecycle process. So that's really what we developed it to do, to be industry specific, cutting edge AI, combining training so that people actually know how to use it and how to read it.
Yeah. And I still, it's just such a hard area to try to teach somebody on. It really is.
It is. I mean, I love teaching people on it, but yes, it's a very hard area.
And especially to make it plain English. All right. So if somebody wanted to find out more about you or about First Rule, where would they go?
They would go to firstrulecm.ai. So it's First Rule Contract Manager, but firstrulecm.ai. And you can see all about the product itself. You have contact information. The other part is that, when I was a kid, I hated my name. I really wanted to be like David Jones, something like that, because as a kid, you don't want to like stand out. There weren't many Eliots and, let alone Eliot Wagonheim. But if somebody looked up Eliot Wagonheim, now it's an advantage because there aren't too many of us. So, I'm on LinkedIn and I'm on the web, but really it's firstrulecm.ai that I would direct them to.
Yeah. Awesome. Well, thank you so much for taking time to be on the show.
Yeah, thank you. I really enjoyed it.